Hi there, everybody. Thanks for tuning into this special edition of Courtroom Insider. I'm Nate Eaton, and today we are going to break down the appeal that has been filed in Lori Vallow Daybell's Idaho case. This was filed May 30th of 2025, just a week or so ago, and it came more than 2 years after she was convicted of killing her two children in Idaho, JJ Vallow and Tylee Ryan. She was also convicted by that same jury of killing Tammy Daybell, the former wife of her husband, Chad Daybell, along with some other charges, including grand theft involving insurance. Now, this took 2 years for this appeal to get processed and filed and finally hit the docket. That's not unusual. This was a very serious case. And what the appellate attorney is doing, Craig Durham, is that he is going through not necessarily the evidence that was presented or the DNA or what one witness said about this or that. He could look into those things. This is more looking at the way the case was presented or the legal filings that happened before the trial or whether the judge erred in doing this particular thing versus that particular thing. It's more of an overarching look at the entire case. He and his team had to read through every single word of every single hearing, the transcripts of all of the hearings to make sure that nothing legally was done in error. And now they are saying that things were done in error. And they're asking the Idaho Supreme Court to review the case. This is not unexpected. This is not unprecedented. In fact, this is par for the course. He's filed this brief. The state attorney general, it will represent the prosecution's team. So Rob Wood, Lindsey Blake, their team, they're done. Now the Idaho attorney general will defend them and the court, Judge Boyce, in the way things were handled. Durham can then respond, and it will go back and forth probably for years, the next year or two. I cannot believe it's already been 2 years, to be honest with you, that since we had the guilty verdict, because I'm obviously still here in Arizona covering this other trial involving this same defendant. And then ultimately, this will end up at the Supreme Court. And the Supreme Court will likely hold oral arguments where Craig Durham will go and he'll speak. I believe they get 20 minutes where he'll speak. And then the Attorney General will speak for the same amount of time. I think it's 20 minutes. And then the Supreme Court will ask questions of both sides, if they wish, the justices. And then they will go and issue a written ruling sometime. Could be in a week after that. It could be in a month. Could be in 6 months. And they will say, we believe, one, that this court did everything accurately and that the verdict stands, or two, we believe that the court was in error and thus Lori Vallow Daybell deserves a new trial. So that's how the process will work. Lori will not attend that hearing, most likely. I don't see them. I mean, maybe she could attend. I don't think she will, though. It will mainly be the lawyers there arguing. Now, this appeal is over 30 pages. It's the opening brief. Things will add to it because the Attorney General will respond to what Craig Durham said, and then they'll kind of go back and forth. I'm going to go through it with you, not super in depth, because I'm not an attorney, and a lot of this is legal speak. But to boil it down for you, there are 5 reasons why Lori's attorney believes she deserves another trial. The first one, and this is legalistic, I'll break it down for you. She was deprived of her Sixth Amendment right to counsel, meaning an attorney, of her own choice when the judge disqualified her retained attorney. We'll get into this in a minute. Remember her first attorney, Mark Means? The judge disqualified him from the case. One of the arguments on why they say she needs a new trial is because she wanted Mark Means to represent her, and the judge violated her rights when he removed Mark Means from the case. Reason number 2, she was deprived of her Sixth Amendment right to the assistance of counsel during pretrial hearings on state's motion to disqualify her counsel after the judge denied her attorney's request to participate in those hearings. A lot of words there. Basically, what they're saying is that the judge held pretrial hearings with the state to talk about disqualifying Mark Means, And Mark Means was not allowed to participate in those hearings. And they're saying because Mark Means was not allowed to be in those hearings, Lori Vallow deserves a new trial. Reason number 3, she was deprived of due process under the 14th Amendment when the judge held pretrial hearings that affected her rights in her absence when she was incompetent. Do you remember that Lori Vallow was sent to the state hospital for about 10 months and declared incompetent? During that time, hearings were held about her mental status, like updates. None of those hearings were public. We weren't allowed to go to any of them. They're saying, her attorneys are saying, because the judge held these hearings while she was incompetent, her rights were violated, and because of that, she deserves a new trial. 4th reason, the judge erred in allowing uncharged acts in Arizona into the Idaho trial under 404B. 404B is that you cannot bring in evidence related to other crimes into other alleged crimes or whatnot into different trials unless there's overwhelming reason why you would need to. The state of Idaho did tell the judge and ask the judge to bring in some of that evidence from the Arizona trials, which we're in right now. The judge allowed some of it, not all of it. You may recall, if you go back and listen to the proceedings with Jim Archibald and John Thomas, they objected anytime Arizona stuff was mentioned. And they said 404B, for appellate reasons, we want it on the record. This is no surprise that this is one of the reasons that her attorney listed in her being having an appeal. And then the final reason, they say that Judge Boyce erred in denying her motion to dismiss based on violation of rights to a speedy trial. Remember how Lori repeatedly, over and over, refused to waive her right to a speedy trial. Yet, the trial was scheduled outside of the window of the 6 months. And now they're saying because the judge did that, she deserves a new trial. So those are the 5 reasons why her attorney, Craig Durham, says she deserves the new trial. So now let's dive into the appeal. Again, I'm not going to get super technical here. And I just want you to have an idea of what was in there, what was said, what they're saying. I promise I won't be here for an hour. Let me take a drink. Here we go. You ready? By the way, you can read the entire thing. You go to eastidahonews.com/Daybell, and there's all of our Daybell stories. And you can click on the link and you can read it. I'll link to it in the description in YouTube too. Here we go. State of Idaho versus Lori Noreen Vallow, aka Lori Noreen Daybell. There's the case number. This is the brief appeal from the District Court of the 7th Judicial District in and for the County of Fremont, the Honorable Stephen W. Boyce presiding. There's Craig Durham. He is the attorney for the defendant. There's a table of contents, as you can see. And it goes through pages and pages, the argument, the conclusion, it's 63 pages. Here's the table of contents. I'm not going to read you each and every one of these cases, but these are the cases that are referenced throughout, along with Idaho statutes and other authorities. Statement of the case. This is Lori Noreen Vallow's direct appeal from the district court judgment imposing a controlling term of life in prison without the possibility of parole for her convictions of 2 counts of first-degree murder, 3 counts of conspiracy to commit first-degree murder and grand theft, and 1 count of grand theft. Ms. Daybell respectfully contends several prejudicial errors tainted the fairness of the proceedings in the district court. 3 appellate issues surround the district court's mishandling, early in the case, of the state's quest to remove Ms. Daybell's retained attorney. First, on the merits, the district court's ruling disqualifying her attorney violated her fundamental Sixth Amendment right to counsel of her choice. Second, the court deprived Ms. Daybell of her Sixth Amendment rights to the assistance of counsel at a critical stage when it erroneously routed the disqualification issue into the companion case of State versus Chad Guy Daybell and did not allow her counsel to intervene in her behalf in that case. Third, the court violated Ms. Daybell's 14th Amendment right to due process of law when it heard and decided this issue while Ms. Daybell was incompetent, her case was stayed, and she was not present. The district court also erred in permitting the state to present wide-ranging, uncharged, quote, bad acts evidence at trial under 404B. And finally, this trial should have never happened because Ms. Daybell's right to a speedy trial was violated. This court should reverse the district court's judgments on any of these grounds. They're saying if the Supreme Court finds one of those things happened out of the five, she should get a new trial. Not all of them. The Supreme Court could come back and say, nope, this one was fine, this was fine, this was fine. This one, though, there was a problem. And because of that specific one, she deserves a new trial. It does not have to be all five. We'll look into it a little bit more here. Now, here in the beginning of this argument is the background. I'm not going to go through it. This is the statement of facts. We all know, if you've been following the case, if you don't, do a deep dive and find all about it. Talks about Lori's background, being a member of the Church of Jesus Christ of Latter-day Saints. It talked about Melanie and Zulema driving to St. George to attend Preparing a People. When Lori met Chad, Lori, and others believed they had multiple probations, multiple lives. Chad had a near-death experience where he gained spiritual insight, and he told Lori that he claimed to be able to see beyond the veil. After they met, Chad and Lori continued to see each other. Chad taught a circle of friends about light and dark. I mean, this really goes into what came out at the trial. It talks about what happened here in Arizona on July 11th when Charles came to pick up JJ and was shot and killed by Alex. Then it talks about that the baseball incident there at the home. It goes on to talk about JJ getting Social Security benefits because he was the only child that survived. Lori checked into the life insurance policy. I mean, really, it goes deep. And the introduction, you have to think of it this way, that the Supreme Court, they may have read news stories, they may have followed the trial, but you have to come at this as if you don't know any evidence. And I can just imagine them reading through this like, wait, what? Wait, what? Huh? Draw the diagram out that we all are familiar with. And then it goes on to talk about Brandon being shot at, him stepping on the gas, getting away from the shooter, Chad and Lori going to Hawaii, Alex marrying Zulema, the children's whereabouts being unknown. And then Tammy's body being exhumed and examined. The coroner changed her death to asphyxiation from natural causes. The children's whereabouts continued to be unknown. Law enforcement intensified their investigation. And then in February of 2020, police officers arrest Lori in Hawaii on 2 felony charges along with a misdemeanor charges. She was extradited to face those charges. Now we go through the course of proceedings. I tell you what, as I was reading through this yesterday, I was like having flashbacks of reliving all of this because I have like videotape and I've written down my notes like as all of this was happening. Immediately upon her return, Lori retained Mark Means as her counsel, with Chad supplying the funds to hire Means. He entered his appearance as Lori's co-counsel in the desertion case. He eventually became her sole attorney. Remember that first trial? It was Mark Means, Edwina, and then one other trial, or one other attorney. Quickly, those two left and Mark Means stayed on the case. Around the same time, Chad retained John Pryor to defend him against any forthcoming criminal charges. Pryor took the place of a previous attorney that Chad had retained, but who did not intend to represent Chad if a criminal case came to fruition. Several weeks after Means entered his appearance on April 20th, 2020, he issued a press release that he represented Chad and requested the media to, quote, please direct all requests for communications and statements of the like to this office. He posted a similar message on his Twitter account. That same day, Lori called Chad from a jail phone. In that call, Chad indicated that Mark Means currently represented both Lori and him to some extent, though Chad told her he was eventually, quote, going to go with the other guy, meaning John Pryor. At Lori's bail reduction hearing, Means informed the judge that he represented both Lori and Chad. Now, this is important. This is critical because this is why Means ultimately was removed from the case. Because there was a conflict of interest when you had two co-conspirators, Chad and Lori, you can't represent both. We'll get to that. Within 6 weeks on June 9th, 2020, police searched Chad's property and discovered the bodies of the missing children. While the search was ongoing, Chad attempted to drive away from the scene, but was arrested. Based on the evidence found during the search of the Daybell property, the state charged both Chad and Lori. These were the first criminal charges against Chad. Mark Means again appeared as Lori's case. Lori's attorney in her case. John Pryor now appeared in Chad's case as counsel. So now Lori's appellate attorney is going to try to dive deep and show the Supreme Court why Mark Means should not have been removed as her attorney. Number one, it says the state's first attempt to remove attorney Mark Means. At Lori's initial appearance on the destruction of evidence charges, the judge asked Means whether he represented any co-conspirator listed in the complaint. Means responded that he did not. The state moved the court to deny Means entry into the case and appoint new counsel for Lori, arguing that Means had a potential conflict of interest after previously holding himself out as counsel for both Chad and Lori. In support, the state relied on those public statements that Means made in April and May and pointed to the recorded phone call between Lori and Chad when Chad suggested that Means represented both of them. So they're saying there that the prosecutor was concerned that Mark Means told the judge no because Means had publicly said he was representing both of them. And also in that phone call, Chad had said to Lori, yeah, he's our attorney for both. This is getting really legalistic, I know, but this is one of the key arguments here. Means countered that he had at most represented Chad in a limited capacity for a brief period before he had been charged, Chad. He reasserted that Chad had separate counsel in criminal matters, which was John Pryor, who also informed the judge on more than one occasion that there was no conflict of interest. And even if there was, it had been waived through a written waiver signed by both Chad and Lori. Means gave that waiver to the judge. Means further claimed he'd consulted with the Idaho State Bar, who described the relationship as, quote, limited representation, or, quote, having a cup of coffee with Chad Daybell, and that the representation, if any, ceased the moment Mr. Daybell retained John Pryor. The judge held a hearing on the issue and inquired of Lori whether she had reviewed and signed the written waiver. She waived any conflict on the record. She said it was fine. She indicated that she had, as did Chad at a later hearing. The judge concluded that while Means had represented both Chad and Lori before Chad was charged, creating a conflict of interest, both Lori and Chad had knowingly and voluntarily waived the conflict. 10 months later, May of 2021, the state charged Chad and Lori with murder, conspiracy to commit murder, and theft. Although the state charged both defendants in a single indictment, the district court assigned two different case numbers. This decision would have lasting implications moving forward, her attorney writes. Before Lori was arraigned, the district court found her mentally unfit to proceed and suspended her case, told her to go to the Department of Health and Welfare. She was there for 10 months. The court ordered that all proceedings in her case ceased, except matters related to the competency issue. Around the same time, Mark Means filed a notice of appearance as Lori's counsel in the murder prosecution. He now represented her in all three cases against her. You're saying all three cases? The state, once they charged her with the murder and those more serious charges, they dropped the other ones because they had her on the serious ones. Given the death penalty was also an option, the court appointed Jim Archibald to be co-counsel for, not co-counsel, I should say, second counsel, second chair, with Mark Means being in charge. The state then tried again, successfully, to remove Mark Means as an attorney. And this appeal goes on to say, while Lori's case was stayed, the state revived its attempt to disqualify Means based on his alleged brief simultaneous representation of both Chad and Lori before Chad had been charged over a year earlier. The state filed this motion under both Chad and Lori's case numbers. Perhaps in response to the state filing of the motion in both cases, the district court entered an order reiterating that each defendant had a unique case and case number. The court confirmed that the cases are two separate cases regardless of the single indictment, and that they will later only be joined for a single trial, which of course ended up not happening. They different cases, but they were going to join them one trial. The court ordered the parties to file all subsequent pleadings in each case, captioning only the individual defendant's respective case number and name. There was a hearing to disqualify Means, but because Lori's case was on hold, it set that hearing only in Chad Daybell's case. So it was set for Daybell's case, but not for Lori's case because her case was on hold. Mark Means filed a motion for intervention so he could be heard on the issue of his own disqualification. He wanted to intervene in the Chad Daybell one because Lori's was on hold. In his motion, he argued that he needed to present the facts and events necessary to resolve the disqualification issue. He also noted that Lori had a right to counsel her own chosen counsel of record, and that the prosecution, quote, took a personal interest in obstructing her constitutional rights. Means and Archibald were present at the hearing, and so was John Pryor. And Chad did not initially attend because Pryor said, quote, I see no basis for the court to go forward on this conflict of interest case. Pryor said, this motion is more properly brought in the Vallow case. He repeated this sentiment multiple times throughout the hearings and said it needs to be brought in the Vallow case. The district court noted it's probably worth sorting this issue out. And then it quickly moved on Means' motions to intervene in Chad's case. Means argued that the state was circumventing the stay in Lori's case by arguing the motion to disqualify him in Chad's case. He's saying, hold up, this shouldn't be happening in Chad's case. It should be happening over here in Lori's case. He claimed that he shouldn't have to file a motion for intervention because the motion is pending for both of the cases. A lot of confusion here if you're following it. At least it appears to be. So when the state agreed that Means really was in the single case, it disagreed with the state's court order splitting them. It still objected to his request to be heard in Chad's case. They said he's got to be heard in the other case. So the state went on to say the court allowed Means and Archibald to observe the hearing, but they weren't allowed to speak. So they could observe, but they couldn't participate. The state steered the direction of the hearing, which happened in 2021 on August 30th, and then it was continued to September 8th, to focus on Chad's rights to conflict-free counsel rather than Lori's. At the hearing, the court admitted the audio recording of the jail call, which Chad indicated to some degree that Mark Means was also his counsel at the time. But that he was going to go with, quote, the other guy. Eventually, the court came around to the state's view, noting that it needed to explore the nature of any potential conflict. Pryor again suggested that if the court wants to go on a way of inquiry, the inquiry should probably take place in the Vallow case. The court took the matter under advisement. Got all that? So Lori's case is on hold. State's saying Mark Means should be off the case. He's arguing he has the right to stay on the case, but he really can't argue because everything's on hold. So he intervenes in Chad's case. Chad's attorney's like, hold up, this is the other case. It shouldn't be happening in our case. It should be happening in their case, but it's still kind of a joint case for trial. Within a few weeks, the court held an ex parte hearing in which only Chad and John Pryor were present. There, Chad clearly expressed his view that he did not consider Mark Means to be his counsel at any point. At the time that Means had made his public statements about representing both Chad and Lori, Chad had hired Pryor, but he did not necessarily want it to be known publicly that he'd hired a criminal attorney. In any event, Chad informed the court he did not provide Means with any confidential information that he was worried about being exposed. To the extent that there was any potential conflict, he consented to Means to continue representing Lori. The court took the matter under advisement. Now, do you remember during all this, an issue came up with Lori calling the Church of Jesus Christ of Latter-day Saints legal department in Utah after someone apparently at the Department of, wherever she, Health and Welfare, the hospital where she was at, told her to do this apparently. While the motions for Means disqualification was pending, an issue bubbled up regarding Lori's communication with an attorney for the LDS Church. Means learned that a clinician at the state hospital had allegedly urged Lori to call the church to inquire about the possibility of obtaining legal counsel paid by the church to take the place of her appointed public defender, Jim Archibald. We can surmise maybe that Lori was upset about having Jim Archibald, so this clinician or someone said, call the church and see if they can provide you an attorney. That's how it sounds like it went. Based on that, she did call them, by the way. Means filed a motion alleging certain violations by the state, contending that Lori had spoken freely with an attorney for the church who had indicated he might help her find additional counsel, only to turn around and give the information to the prosecuting attorney. The attorney for the church called the prosecutor. Means issued subpoenas to various entities to get to the bottom of the contact between the church and the prosecutor. The state responded by denying any impropriety, claiming that the prosecutor had a very short conversation, about 1 minute, with an attorney at the law firm representing the church before notifying co-counsel Archibald of the contact. So the church attorney calls Rob Wood. Rob Wood speaks to them for about a minute. Rob then lets Jim Archibald know what's happening, and Archibald happens. Means allegations and legal machinations, hope I said that right, clearly touched a nerve with the state, which again urged the court in their responsive following that Means had, quote, unwaivable and unethical conflict of interest due to his past dual representation. The state further argued that Mr. Means' continued involvement in this case is inappropriate and creates an issue for appeal. Within a month of the dust-up, the court granted the state's motion and disqualified Mark Means as Lori's counsel. It concluded that Means had represented Chad for at least a period of time, that the representation created a conflict of interest, and that the court would not honor a waiver because of the severity of the case. Lori Vallow was still in the state hospital. She was not permitted to choose her own attorney. That's what they say. Now, I imagine the attorney general is going to come back and argue that point and say the judge had to be careful, because if it had proceeded and there was a conflict and Mark Means had all this information, it could have created another serious issue that maybe they could have used that on appeal to say she had an attorney who represented both of them. So that's an interesting argument that they lay out. And again, this is what they are alleging. And I want to let you know that the attorney general will respond to that and with their own argument to say, no, the judge was right in dismissing Mark Means. So that's reason number one. You got all that? We got 4 more reasons. I'll go quicker. Second one was about her competency. Lori Vallow then regained her competency and demanded a speedy trial. So one of the second issues is she was not given a speedy trial. First issue, she didn't get to choose her attorney because the judge dismissed Mark Means. Her competency was restored on April 11th, 2022. The district court lifted the stay in the case. She was arraigned on the charges. The state filed a notion that it was going to seek the death penalty. John Thomas was then appointed as co-counsel to Jim Archibald. At her arraignment, Ms. Daybell demanded her right to a speedy trial, a position she reiterated repeatedly throughout the case. Cannot deny that. That was true. It's true here in Arizona. That's why she's representing herself. The case was set for trial the following October. Almost immediately, the state filed a motion to continue. Over her objection, the district court granted the state's request and reset the jury trial to begin in January of 23. In September, Ms. Daybell's counsel received information from a mental health professional that they believed required a re-investigation of her competency. Do you remember that? She was then incompetent again for like 9 days or something. They filed a motion to continue the trial and told the deadlines for pretrial filings. At that motion, Ms. Daybell expressly disagreed with the findings of the mental health evaluator and objected to the continuance. She told the court that she believed that the assessment was an attempt to prolong the case and, quote, I am unwilling to give up my rights to waive my right to a speedy trial. Nonetheless, the court granted a continuance and held a competency hearing in November, after which it again found Ms. Daybell competent to proceed. It reset the trial to April 3rd, 90 days later than the January setting. Ms. Daybell moved to dismiss the case, claiming her speedy trial rights were violated. The court denied the motion. We knew this was coming, at least those of us that followed it. We assumed she would appeal based on that. She's going to probably appeal based on that here in Arizona, because the Brandon Boudreaux trial that's happening now is, I think, like 11 days outside of that window. So we'll see. We'll see if the Supreme Court. Now, I don't know how strong this argument is, because there were reasons, and her attorneys at the time, I think they made note on the record, Jim Archibald at least, that they wanted more time, but their client did not. They could have had another year to put together a case and really get it strong, but Lori did not want to. So the 2 reasons: 1, Mark Means got booted and she didn't want that. She didn't get to choose that. 2, her speedy trial rights were violated. 3, the fact that they introduced bad acts from Arizona into the Idaho trial. Some 8 weeks before the trial, the state filed a motion to introduce evidence under Rule 404B of the Idaho Rules of Evidence. In that motion, it listed the general nature of the evidence which it sought to introduce, including some 27 categories of evidence related to Charles Vallow's death, Lori's previous husband's death, and other evidence. Ms. Daybell's counsel objected that the state's motion failed to give them reasonable notice. They argued that the state intended to introduce an enormous amount of evidence from Arizona at the last minute, essentially another case or cases. Quote, the state has been hiding the ball on this issue for at least 1 year, 8 months, and 16 days, the time between the grand jury indictment and the proposed date of the hearing. The court expressed some agreement that the state's motion was overbroad and vague, which prompted the state to file an amended motion to introduce the 404B evidence. So it sounds like the state went with all this stuff from Arizona and said, boom, we're going to introduce this into Idaho. Her attorneys objected, and the judge said, all right, you got to narrow it down, and that's what they did. In the amended motion, it indicated it intended to introduce evidence primarily related to the circumstances surrounding the death of Charles Vallow and the attempted shooting of Brandon Boudreaux, Melanie Pawlowski's ex-husband. The defense again objected, noting the enormity of the evidence and the burden it would put on the defense to investigate all of those matters before a trial that was set to begin in a few short weeks. The court granted the state's amended motion with a few minor exceptions. It concluded that the evidence related to the shooting of Charles Vallow, the investigation into the shooting, and related matters were permissible to show the defendant's plan, preparation, knowledge, or identity. It likewise allowed evidence of the attempted shooting of Brandon Boudreaux also to show preparation, plan, knowledge, and or identity. It concluded that the probative value of the evidence was not outweighed by the danger of unfair prejudice. If it had concluded that it was outweighed, then the judge wouldn't have let it in. But he did. And because of that, that's another reason they're saying they let in the Arizona evidence, they didn't let her choose her attorney, and she didn't get a speedy trial. Now, another thing that isn't necessarily a reason, but that they included in this thing is that when the district court, when the judge struck the death penalty, because Chad waived his right to a speedy trial. Because of that, the death penalty was kept on the table. And he obviously has been sentenced to death. The Lori, because she did not waive her right to a speedy trial, her appellate attorney is bringing up the fact that the prosecutor introduced evidence late, and because of that, well, here, I'll just read it to you. Less than a month before the trial, the state dumped additional discovery on the defense well past the discovery deadline. This was a pattern throughout the case. The defense filed a motion to strike the death penalty as a sanction for the state's discovery violation. The court granted the motion. The court concludes here that as an appropriate discovery sanction, the state will be precluded from seeking the death penalty at trial, and the state's May 2nd, 2022 notion to seek the death penalty will be stricken. Because Chad had waived his right, I talked about that. So they took the death penalty off the table. And then they go on to summarize the trial. It proceeded as scheduled. It lasted about 6 weeks with 60 witnesses. In addition to the basic historical facts recited in this brief, the state's case at trial relied on other circumstantial evidence, including cell phone geolocation data, placing Alex Cox at the burial sites, evidence of text messages and emails exchanged among the alleged co-conspirators, and witness testimony about Lori and Chad's religious beliefs and statements. The defense countered that there was no physical evidence tying Lori to any of the deaths, that the alleged conspiracy to murder anyone was entirely circumstantial and speculative, and that the state was using prior bad acts to shore up its case and imply guilt. The jury found her guilty. The district court sentenced her to 3 consecutive life terms in prison without parole, and 2 concurrent sentences for the conspiracy and 3 concurrent sentences for the grand theft. Okay. And they say that out of the 60 witnesses, there was 19 who testified in whole or in part about Arizona. So you got all that? We went through the 3 issues already. I'm not going to go through all of them again, because now they have a whole section on issues presented on appeal. We talked about the right that she didn't have to her counsel, and then the issue that they had a hearing where her own attorney wasn't allowed to speak, that while she was incompetent, she didn't get to participate, that the 404B rules were introduced, and that she didn't get her speedy trial. Did I cover them all there? Okay, I think I may have. So again, the 5 reasons why they're saying, and I'm not, you can read it all. You can read it all. I'll fast forward here till the end. Normally there's like a summary that you can go through and kind of see it all. And they have really gone deep into this. I can tell you that. It's an appellate thing. Normally we don't cover appeals much, because they're a lot of work to continue to follow, and they can be far more legalistic, obviously. But let me go to the conclusion. Lori Daybell respectfully asks this court to reverse her judgment of conviction and remand for an order dismissing all charges against her based on a violation of her statutory and constitutional right to a speedy trial. Short of that, this court should reverse the judgment of conviction and remand for a new trial based on the errors raised on issues 1 through 5. Respectfully submitted on the 30th day of May, 2025. So that is how it wrapped up. And again, to walk you through those 5 issues here, let me pull up the slide that has them. The first issue was Lori's Sixth Amendment right was violated when the judge disqualified her retained attorney. The second issue was during pretrial hearings, the judge denied her attorney's request to participate in those hearings. The third was the judge held pretrial hearings that affected her rights in her absence when she was incompetent. The fourth was that he erred in allowing the 404B Arizona stuff in. And then the fifth was that he violated her rights to a speedy trial. Now the Idaho Attorney General has 60 days to respond. I imagine they'll probably ask for an extension, which is not uncommon. They'll ask for an extension. They could ask for multiple extensions. They could take another year or two to respond. But that is where we're at today. Now, if you want to read the whole brief, go to eastidahonews.com/Daybell. This is where you can actually find all of our Daybell stuff right here. Daybell trial, scroll down, and the story will be right up here at the top. There's where you can find our digest, which is a newsletter we send out every day on the trial. Courtroom Insider, you can watch our previous episodes here. Frequently asked questions, a timeline of the case, who's who, and all of our videos, which we're approaching 1,000. Can't believe it's been 1,000. And then here's where you can sign up for the inbox. Actually, the digest, when you click on, it's the updates that I post from the courtroom every day. So hopefully that helps you. You can go read the appeal if you're big into it. Many of you are like, oh my gosh, what if let's say that the Supreme Court did grant one of these issues and say, you're right, she deserves a new trial. What would happen? I would imagine, I don't know. I would imagine she'll be released in Idaho and they'll send her to Arizona where she'll serve her sentence for Charles. She remains in Idaho. Once Arizona wraps up, so we have to finish the Brandon Boudreaux trial this month. Then the judge will set a sentencing date here in Arizona for the Charles and the Brandon cases. That'll probably happen this summer sometime in the next 30 to 60 days. She'll get sentenced. She leaves Arizona at that time and goes back to Idaho, where she serves her sentence for life. If that sentence gets vacated, if they find there was an error in Idaho, and they have to redo the trial, she'd be released from Idaho, but then she'd come back to Arizona and serve the time, assuming she's sentenced in Charles Vallow's case. She'll get 25 to life, so she'll have at least 25 years here. And then when the trial happens again in Idaho, she'll go back. Could you imagine if we have one more trial? They have to redo it all over again? Who knows? Who knows with this? You know, just when you think nothing crazier can happen, it does. And it always does. Here's where you can find me posting all the updates on Facebook, X, Instagram, and YouTube, East Idaho News. Big shout out to our sponsor, newspapers.com. If you love history, if you love crime, if you love both, you got to go to newspapers.com and you can get a 20% off discount on your membership if you go to newspapers.com/Nate. They are sponsoring Courtroom Insider. They've been a great partner to work with over the past few weeks, and we appreciate their sponsorship. We appreciate you watching this deep dive of the appeal. And later on tonight, or whenever you're watching, we will have our normal edition of Courtroom Insider as normal live. Just wanted to, do an afternoon version today of everything that's happening with the appeal, and hopefully it can, educate you a little, or at least you can go on and read it yourself. Not that I'm the smartest guy in the world, but hopefully that helps you. I'm Nate Eaton. Thanks for watching Courtroom Insider. We will see you next time.